Good morning, everyone. I call this session of the Public Service Commission to order. Madam Secretary, are there any changes to the final agenda?
There are no changes to the final agenda.
Thank you. I'd like to note that Commissioner Valesky will not be joining us today due to an excused absence. Before moving to the agenda, I'd like to conduct a roll call of commissioners. When I call your name, please confirm that you are present. Commissioner James Alisi.
Present.
Commissioner John Majori.
Present.
Commissioner Chenna Bright.
Present.
Commissioner Denise Sheehan.
Present.
Commissioner Radina Volova.
Present.
Thank you. Before we turn to the regular agenda, do any commissioners wish to recuse from voting on item 101, 201, or 301? Commissioner Alisi.
No.
Thank you. Commissioner Majori.
No.
Thank you. Commissioner Bright.
No.
Thank you. Commissioner Sheehan.
No.
Thank you. Commissioner Volova.
No.
Thank you. We now move to the regular agenda. Our first item for discussion, item 101, case 23-G-0627, which addresses the national fuel gas rates. It'll be presented today by Judge Michael Clark and Judge Tara Kersey. Dakin Lee Cakes, Eric Ryder, Brandon Goodrich, and Jeff Hogan are all available for questions. Judge Clark, please begin.
Good morning, Chair Christian, Commissioners. My name is Michael Clark. I was assigned to preside over this proceeding with Administrative Law Judge Tara Kersey. Item 101 is a draft order that would approve, with minor modifications that I'll expand on shortly, a joint proposal that establishes a 3-year rate plan for the National Fuel Gas Distribution Corporation for the time period running from October 1st, 2024 through September 30th, 2027. The JP is signed by NFG, DPS staff, multiple interveners, IBEW Local Union 2199, and IBEW Local Union 2154. The Department of State's Utility Intervention Unit did not sign the JP, but does not oppose it. The Public Utility Law Project, or PULP, the National Resources Defense Council, and the Alliance for a Green Economy, AGREE, raised various arguments in opposition to the JP, most of which have already been rejected by the Commission in recent utility rate proceedings. These arguments include that a fixed ROE during the term of the rate plan is against the public interest, that the JP includes excessive investments in traditional gas infrastructure, and that the JP impermissibly allows the company to charge ratepayers for political activity aimed at undermining New York's climate goals. As background, NFG commenced this proceeding in October 2023, seeking an $88.8 million increase in base delivery revenues driven by higher O&M expenses, inflation, and heightened regulatory requirements, among other things. Testimony from DPS staff and interveners was submitted in March 2024, with staff recommending a $34.5 million increase, or approximately $54 million less than was requested by the company. Shortly thereafter, NFG filed a notice of impending settlement discussions, which continued through the spring and summer and culminated with the filing of the JP on September 9th. An evidentiary hearing was held on October 29th, at which almost 600 exhibits were entered into the record, and AGREE conducted cross-examination of a witness panel comprised of representatives from NFG and staff. As I indicated earlier, the JP establishes a 3-year rate plan running from October 1st, 2024 through September 30th, 2027, with new rates becoming effective on January 1st, 2025, subject to a make-whole provision that allows NFG to recover rates for the 3-month period from October 1st until December 31st, 2024. On an unlevelized basis, the JP adopts increases of $57.3 million in rate year 1, $15.8 million in rate year 2, and $12.7 million in rate year 3. To minimize the impact of the first-year increase on ratepayers, however, the JP would levelize the increases to $37.1 million in rate year 1, $34.7 million in rate year 2, and $35.6 million in rate year 3. On a total bill basis, this results in 4.42% increases in all 3 rate years. The order rejects arguments from the opposing parties that the rate increases are too high, with one significant reason being that this is NFG's first rate increase since 2017 and only its second since 2007. Both of those proceedings resulted in fully litigated rate orders, with the Commission approving a $1.8 million increase in 2007 and a $5.9 million increase in 2017. The Commission performed one additional review of NFG's rates in 2014 when it initiated its own proceeding due to concerns that the company may have been over-earning. At the conclusion of that proceeding, the Commission approved a JP that froze rates at the 2007 levels and provided NFG customers with a $7.5 million refund. The company's $15.54 minimum monthly charge has remained constant since 2007, as has, largely, the delivery portion of the average residential customer's bill, which was $38.81 in 2008 and $38.86 in 2023. In contrast, inflation has risen approximately 24% since 2017, and the company's costs to remove 1 mile of leak-prone pipe have grown by 56% in the last 6 years. These costs are likely to grow even higher as a result of the New York State Roadway Excavation Quality Assurance Act, which was enacted in September 2023 and subjects certain contractors who perform work for NFG to prevailing wage requirements. It is nevertheless notable that, even with the increases proposed in the JP, NFG's monthly delivery charges will be among the lowest in the state. Excuse me. The JP allows a 9.70% ROE and a 48% common equity ratio for all 3 rate years, which is the product of a settlement compromise and falls within the range of the 9.8% proposed by the company and the 9.25% recommended by staff. Further, the proposed ROE is reasonable given the economic environment at the time the JP was signed by the parties and filed, which reflected higher return requirements than when staff initially filed its testimony. While Pulp continues to advocate in favor of an ROE that is updated annually, the Commission has recently observed that a settled, fixed ROE permits rates to be set over multiple years without the risk of year-to-year fluctuations, and thus protects ratepayers from being exposed to the volatility of frequent rate changes. A fixed ROE also allows the company to borrow money on favorable terms, as it supports the company's credit ratings, and it incentivizes the company to create cost efficiencies and productivity gains that may lead to lower costs, which can then be reflected in future rates. The JP includes an earnings sharing mechanism that acts as a safeguard against potential excessive over-earning and ensures that ratepayers share in any efficiency gains realized by the company. It is triggered if the NFG's actual return exceeds 10.20%. The JP supports planned gas capital budgets of $120.9 million in rate year 1, $120.0 million in rate year 2, and $121.5 million in rate year 3. Figures that fall within the range of possible outcomes in a litigated proceeding and that are actually very near staff's initial position. The order accordingly agrees with the signatory parties that these budgets are reasonable and necessary to ensure the company's continued provision of safe, reliable, and adequate gas service. Additionally, as part of its annual review of proposed capital projects, the JP requires the company to consider non-pipes alternatives, or NPAs, in accordance with its NPA suitability and criteria process, and document that consideration, including reasons for pursuing or not pursuing an NPA for each particular project. Turning to leak-prone pipe, the company began its systematic removal program in the 1990s, identifying and prioritizing the removal of various types of pipe prone to leaking, some of which was installed in the 1800s. Since commencement of the program, NFG has eliminated about 3,000 miles of leak-prone bare steel, cast iron, and wrought iron mains, leading to a 69% reduction in annual greenhouse gas emissions from its gas distribution system. The company's remaining approximately 1,200 miles of leak-prone pipe, about 90% of which is more than 60 years old, is nonetheless the 15th most of the more than 1,330 gas operators in the nation, and the Commission has previously stated that its continued removal is an ongoing priority until the inventory no longer exists. Benefits to leak-prone pipe removal extend beyond public safety and include improved system reliability and fewer interruptions, lower overall leakage rates, and reduced operating, maintenance, and overtime costs associated with surveying leaks and responding to emergency reports. The JP includes 4 distinct programs directly related to managing emissions and supporting CLCPA requirements: a demand response pilot program, hydrogen-related demonstration projects targeted for hard-to-electrify industrial customers, a deep shell retrofit weatherization program, and hybrid heating demonstration projects for small commercial customers. Several other provisions in the JP advance New York's climate goals, such as funding for the installation of a solar array at the NFG Tonawanda Service Center to offset the center's electricity usage, funding for electric vehicle charging stations to help phase in electric vehicles for the company's fleet, and moving toward flat blocks rates. The JP also allows, the JP also allows NFG to solicit purchases of renewable natural gas and to implement a pilot program for the purchase of reliably sourced gas, with both provisions being narrow in scope and tailored to protect customers from excessive or wasteful costs. These provisions also require information gathering and reporting that will provide all stakeholders with valuable information regarding the potential benefits of alternative fuel sources. The JP includes several noteworthy customer service provisions, including a performance incentive mechanism that subjects the company to negative revenue adjustments, funding for a new call center phone system, enhancements to the company's Energy Affordability Program for Low-Income Customers, or EAP, and the expansion of cold weather protections for residential customers. More specifically, the JP establishes targets for 4 customer service performance metrics: the PSC complaint rate, the call answer rate, the residential customer satisfaction survey, and estimated bills, which will incentivize the company to provide customers with accurate bills in a timely manner. If the company fails to meet applicable targets in any of these metrics, it is subject to negative revenue adjustments, which will be held in deferral for the benefit of ratepayers. The JP establishes an EAP budget of $12.8 million in all 3 rate years and includes provisions for improving the company's process for assigning customers to EAP participant tiers. In particular, the JP requires that the company use the annual ODIDA Home Energy Assistance Desk Guide and/or the New York HEAP State Plan, whichever is most current, to update its tiering logic as necessary. Additionally, the signatory parties acknowledge that a dispute exists regarding whether the company properly assigns some customers to the correct EAP tier. The company has recently submitted reports to the Commission concerning this issue and indicated that it has provided credits to certain customer accounts for various periods between October 1st, 2021 and September 30th, 2024. These submissions are currently under review by staff, who can refer any relevant matters for future Commission corrective action as necessary. The JP merges 2 separate heating equipment repair and replacement programs, one for elderly, blind, and disabled customers, and one for low-income homeowners receiving HEAP benefits, into a single program to restore heat to homeowners who are unable to replace or repair their primary heat source. The JP requires the company to apply energy efficiency standards to the program to determine whether installation of energy efficient equipment can occur. The JP recognizes NFG's partnership with Neighborhood Legal Services, or NLS, which provides free legal services to low-income individuals and persons with disabilities. $55,000 in funding for all 3 rate years will enable NLS paralegals to assist customers in obtaining valuable emergency assistance or HEAP benefits, preventing gas shutoffs, or restoring service. The JP also requires that the company reopen 3 walk-in customer assistance centers in Buffalo, Cheektowaga, and Jamestown, which were closed in connection with the COVID-19 pandemic. And it provides that the company will expand the availability of translated customer outreach materials explaining customer rights and responsibilities, safety, and bill assistance into the top 5 non-English spoken languages in the company's service territory. The JP provides formal protection to customers during the cold weather period between November 1st and April 15th, ensuring that the company will not disconnect service to residential gas heating accounts identified as elderly, blind, or disabled, and on days when the local weather forecast predicts a high temperature below 32 degrees Fahrenheit, the company will cease all residential collection disconnections. Finally, while Agree argues that the JP ostensibly permits the company to charge ratepayers for political activity, Agree itself acknowledges that purported costs associated with the company's advocacy are not apparent from the joint proposal and appendices. The draft order nevertheless makes 3 minor modifications to the JP, arising out of Agree's assertions and the company's statements with respect thereto during the evidentiary hearing. First, through its cooperative advertising program, the company has historically provided funds to other companies, including appliance dealers, contractors, and builders, to promote their natural gas equipment and services. The draft order directs that the company shall not use ratepayer funds in connection with this program during the term of the rate plan. Next, given the company's concessions at the evidentiary hearing that it tracks one particular employee's advocacy-related work only on an annual basis, and that it is unaware if other employees are posting content that this employee creates to social media, the company must confirm that it has reviewed the work performed by all employees to determine who performs advocacy-related tasks and whether they have appropriately allocated their time to the parent company. If the costs of advocacy-related work were incorrectly included in the revenue requirements of this proceeding, the company is directed to defer that amount for future refund to customers. Relatedly, the company is also directed to include information regarding employee work time spent on advocacy-related tasks when it completes the reporting required pursuant to Appendix O of the JP, which will enable staff to determine whether the company is properly charging the cost of that time to the parent company. In concluding that these additional reporting requirements were necessary, consideration was given to a recent investigation into the company's political expenditures conducted by the Department's Office of Investigation and Enforcement, or OIE, as well as the company's implementation of certain recommendations arising out of management and operations audits. Notwithstanding the minor modifications to the JP, however, it should be noted that OIE did not find any violations of the Public Service Law, regulations, or Commission orders that warrant an enforcement action, and the Department's Office of Accounting, Audits, and Finance indicates that the company's audit efforts have demonstrated recent improvement. When reviewing a joint proposal in a rate case, the Commission must ensure that its terms enable the utility to provide safe, adequate, and reliable service at just and reasonable rates. The Commission must also ensure that the settlement's terms, as a whole, produce a result that is in the public interest. Factors considered in this analysis include whether the terms appropriately balance the interests of utilities ratepayers, its investors, and the company's long-term viability, produce outcomes that may have arisen had the case been fully litigated, whether such terms are consistent with the social, economic, and environmental policies of the Commission and the state, and whether they are supported in the record. In light of all of the above, We believe that the JP satisfies these criteria. That concludes our presentation, and we're available for any questions you may have.
Thank you, Judge. And thanks you to the entire team involved in this rate case. Each rate case is unique, and this uniqueness creates challenges for staff and commissioners alike, because we have to look at not just past actions and their outcomes and impacts, but we also need to look at the cost and benefits of what's to come, the future actions. And in performing this review, as emphasized by Judge Clark, we must stay true to our mandate of ensuring that ratepayers have access to safe, secure, and reliable services at just and reasonable rates. Now, in any rate case, parties seek out opportunities to advance positions, policies for specific outcomes. And in these instances, staff and the Commission evaluates these proposals as part of the whole. And again, as Judge Clark pointed out, we incorporate or not based on how they affect the whole and overall benefits. Now, again, unique to this rate case is also the fact that it's the first time they've come for a rate case, NFG, to this Commission since 2016, right? Almost a decade. It's a long time. And I don't think any of the commissioners today, looking at you, Jim, were here around that time. And since that rate case, the rates for NFG have remained unchanged, which is also unique among the major utilities in New York State. Again, a unique situation to NFG. Now, with the passage of time, needs grow more significant. And when you look at the Commission's analysis, the estimated cost of service is what I believe it's referred to as. Is that the right terminology? The ECOS? Embedded, right, thank you. Embedded cost of service, thank you. That actually supports a rate increase of more than double for the minimum charge that we see today. Now, I don't think such an action would be a good thing. I think it would have a very negative impact on consumers. And I want to applaud staff and the stakeholders for negotiating the outcome we see before us. I think where we are with the change in minimum charges takes into consideration the passage of time, the need for needed investments, and also not unduly burdening ratepayers with excessive increases. And so that the parties were able to come to an agreement, I think, is something worth noting and commending, because it doesn't always happen that way. So again, I want to commend staff for their efforts of shepherding us through this rate case process. I want to thank you for your engagement with the utility, NFG, the stakeholders and others, and for ensuring that this process is completed in an efficient and a timely manner. When I look at the record, I too agree, Judge Clark, examining the positions of various parties and the outcomes as a whole, I find this to be in the public interest. So again, thank you for your hard work. Commissioner Alisi.
Thank you, Chairman. I will be supporting this. It is, I should note at the outset, it is less than what was initially requested, and I think that's a significant issue to stress. Nevertheless, it does provide essential customer service improvements that are safe and reliable. The prices are just and reasonable, and that is accomplished without litigation. So it strikes a fair balance for ratepayers as well as shareholders, and based on today's detailed presentation and very thorough briefings earlier this month, I'll be voting yes on it, and I can very comfortably support the proposal. Thank you for your efforts.
Thank you. Commissioner Majori.
Thank you. Thank you, Judge Clark, for your presentation. When I review a major rate case, I'm looking to see if the process leading up to the order coming before us has been transparent, participatory, and thorough. I don't want to raise rates for anyone. I don't think any of us do. So I'm looking to see if there are miscalculations or unnecessary cost recoveries. I'm also looking to see if the order is consistent with the climate law, the CLCPA. In many respects, major rate cases are the bread and butter of the agency, and to date, I have not found a JP that falls short in these respects. The same holds true with this one, which in one sense is a positive testament to the thorough and professional work of staff and the various parties involved and the comprehensive nature of the process, but in another sense is unfortunate because I sure would like to be the one to discover something that everybody else missed, that saves ratepayers money or further reduces the climate impact of a natural gas utility. But I don't see much room to maneuver here, and I would like to ask you a series of questions to either confirm or refute these observations. So let me start with this. In your presentation, you explained what the company asked for in its initial petition and then what the end result was. Can you explain in a little more detail some of what they asked for but then did not get?
Commissioner, the unlevelized rate year one increase is $57 million. That's $31 million less than what the company had requested, the $88 million that they had initially requested. The largest component of the decrease was O&M expenses, which represents $24 million out of the $31 million decrease. Decreases in pension and OPEB costs were $15 million, labor cost decreases were $3 million, and customer processing fees were $2.5 million. They were the largest drivers of the decrease in O&M expenses. There was also a decrease in the rate of return and depreciation expenses. The decrease in the rate of return was about $4.7 million, and the decrease in depreciation expenses was approximately $2.3 million.
Okay, thank you. So the flip side, can you walk us through what some of the major drivers of the increase were?
The major drivers of the increase were depreciation expenses and O&M expenses and the collection of previously incurred regulatory deferrals.
Okay. So it strikes me that we have absolutely no discretion over some of the rate drivers, and then in other cases, we might have discretion over timing, but at the end of the day, the company needs to recover costs for either directly legally required expenses or expenses that are incurred in order for the company to do something it's obliged to do. Can you give any examples of anything left? I mean, you just walked us through some of what was taken out, but anything that's remaining in this JP that could have been cut out, or approximately what percentage of what's left is discretionary?
Commissioner, I'll try and address that question. It would be very difficult to quantify exact amounts that could possibly be cut. I'd say that there's a single-digit percentage of the company's costs that wouldn't be considered mandatory, required, statutory, absolutely necessary to conduct its business. You could get into discussions about whether 10 accountants are needed or 9 accountants, whether or not 4% raises versus 3.5% raises would be enough to retain employees and ensure continued reliable service by the utility. It's really around the edges, though, in terms of what would be, I would say, discretionary. Is there a legal perspective you'd like to add?
Commissioner, I'd like to add a little bit from our perspective in the Office of Hearings, because I think your question gets a little bit more into a fundamental point about the rate case process. From our perspective, there are no costs or no specific examples of costs that are discretionary. So the way the rate case process works is the company files testimony and says that it needs a certain amount to meet its obligations to provide safe and adequate service under the Public Service Law. The other parties, including our department staff who are experts in their field, take a look at the company's filing and review it to find exactly what you're talking about, any discretionary costs or costs that they think that have been overestimated, things like that. And they provide their own testimony as to that, what they think the right outcome is for the company to provide safe and adequate service. The case then either goes in one of two directions. It goes fully litigated, like the recent Central Hudson one earlier this summer, which was a fully litigated case where the judges came before you and provided their own review of the litigated record and said this is what we think are the absolute necessary costs to meet safe and adequate service. Here we have a joint proposal. We have many of those. That's where the parties get together based on the testimony that was filed and come to a negotiated agreement where they say, we all agree that these are the costs that are necessary to continue to provide safe and adequate service for the next 3 years, in this case, of the rate plan. Then our judges take a look at that and determine whether they agree that the rate plan provides just and reasonable rates to meet that safe and adequate charge, and they also look to make sure that the rate plan itself is in the public interest. And by coming before you, as even Judge Clark said in his presentation, our representation is that as far as we're concerned, these are mandatory costs required to meet their safe and adequate charge.
Thank you. So when Judge Clark was saying that one of the reasons for the rate hike was that National Fuel hasn't had a rate increase since 2017, on an even more fundamental level, the reason that we're approving a rate increase is because they have upcoming expenses that they have to incur. Is that correct?
That's correct. A lot of things have changed since that rate order in 2017, and Judge Clark mentioned a few of them, including inflation and other things. We've also had the COVID pandemic, which affected costs on the supply chain for all industries. Basically, the company took a look at where it was relative to the rate plan it received in 2017, and it determined that in order to get its constitutionally required return on its investment, it needed to increase its cost, and they filed a rate case. Staff ultimately looked at what the filing was and agreed that there was some amount that was necessary to continue to provide safe and adequate service, to provide the constitutionally required return, and came back with a number. It was less than the company, so they disagreed with the amount that the company had requested, but all the parties in this case provided testimony that went to the programs proposed by the company that said there is some amount of rate increase that is required here.
Okay. All right. Thank you. I'm going to turn to some of the feedback we've received through comments by parties and members of the public through the public comment process. And I'm going to characterize it this is my language because I'm trying to characterize a thread of comment. That National Fuel should be spending less on infrastructure. And the argument goes along the lines that the climate law, the CLCPA, requires that the state get off natural gas by a point in time, and that National Fuel should essentially be planning to shrink or even shut down. Can you explain the obligation to serve? What is that?
Absolutely. So in New York, gas companies, electric companies, the utilities are required to serve customers. And for gas utilities, the statutory obligation comes from Transportation Corporation Law, Section 12, for non-residential customers, and from Public Service Law, Section 31, subsection 4, for residential customers. To enforce these requirements, the Commission's gas regulations, Part 230, and specifically 16 NYCRR 230.2, obligate gas companies to connect and provide service to any customer who requests such service as long as the requesting customer meets certain basic conditions. The utility does not have the right to turn down a request where it has been granted a franchise by a local municipality under normal circumstances. Where there is a lot of history behind this, it can most succinctly be summarized by the recognition that a franchise generally provides the utility with the right to act as a legal monopoly provider in return for accepting the legal obligation to provide service to anyone who needs and wants essential utility service. And just in conclusion, I want to note that the CLCPA doesn't negate other statutory requirements regarding the Commission's oversight of utilities or their provision of service.
Okay, thank you. So along those lines, there's a term that you've used and Judge Clark used, and people that listen to these sessions here all the time: safe, reliable, and adequate service. That term comes out of the law, doesn't it?
Yes, it comes for gas utilities from Public Service Law, Section 65, which requires the utilities to provide safe and adequate service. And there's a century and more of legal precedent, both by utility commissions across the United States as well as federal courts and commissions, that define adequate as reliable service to meet the expectations of the end users who use that service.
Okay. So my next question is trying to get at whether or not either that provision or law or the obligation to serve contradicts the CLCPA. Does the CLCPA ban natural gas or mandate that utilities shut down the provision of natural gas or prohibit customers from using natural gas? Does the
No, it does not.
CLCPA do any of it? It does not.
It doesn't.
Okay.
And the rate plan itself that we are proposing or supporting here today doesn't contradict the CLCPA. And the Public Service Law also doesn't contradict the CLCPA. So under the law, the legislature is presumed by the courts to know all the laws that exist that go to the same targeted subject area. The CLCPA and the Public Service Law arguably have some overlap, but that doesn't mean that they're contradictory. It's just that the Commission's obligation is to balance those laws and figure out how they work together, and what the Commission ultimately decides on that is subject to review by the courts. But there is no contradiction.
Okay. So just staying with the CLCPA, we've also encountered a line of argument that, again, this is my characterization, so I hope I'm not mischaracterizing somebody's point, that the CLCPA is one of the leading reasons why rates in this case or other utility cases are going up. Would you say that the CLCPA is one of the major drivers of the rate increases here? The rate increase here?
No, I don't think it is. And earlier, Judge Kersey mentioned the rate drivers in response to one of your questions. She did not mention the CLCPA. It's not a major driver of the cost increases themselves, as it doesn't require anything different than what the Public Service Law requires, as I just said, to maintain safe and adequate service. What it does is it may influence the way we interpret safe and adequate service, or the way staff, when it does its review, looks at some of the programs proposed by the company, or even the company itself, when it comes in for its rate filing, looks at the filing that it's going to make. So there's some influence that it exerts over the direction that the utilities are taking over the short and long term, but it itself is not a major driver of the rate increases.
Okay, thank you. Now, in Judge Clark's presentation, he mentioned 4 programs related to managing emissions that support the CLCPA. Are any of those projects specifically required by the CLCPA? Would any not exist but for the CLCPA?
Commissioner, excuse me, they're not required by the CLCPA, but as you suggested, they support the goals of the CLCPA. It's difficult to answer whether or not they would exist. They do have benefits beyond the CLCPA. Weatherization is good for efficiency. Hydrogen or hybrid heating programs perhaps would be investigated as innovative measures to create a more efficient gas system. And just so you're aware, none of those 4 actually have high dollar amounts associated with them. The hydrogen demonstration project is $185,000 in each of the 3 rate years. Hybrid heating is $51,000. Weatherization is $55,000, and the demand response program provides funding for 1 full-time employee. So that's essentially 1% of the $37 million levelized increase.
Okay, thank you. So just a final question, and staying on this topic, as I read this order, I do think, I agree with you, I agree with Judge Lee Cakes that this order is consistent with the CLCPA. And I do think that there are provisions that are in response to the CLCPA. And something that sticks out to me are that the JP brings a couple of economic development programs, the ADP and the Prime Economic Development Program, more in alignment with the CLCPA's clean energy objectives. Can you just explain how we do that with those 2 programs?
Yes. So this was a provision insisted upon by staff that the company modify both of those programs. Any applicant seeking funding through one of those programs will have to demonstrate that they have conducted an NPA analysis in order to be awarded any kind of grant or loan. The company's review will consider technical feasibility, cost effectiveness, impact on the initial project scope, impact on safety and reliability, and the impact on greenhouse gas emissions.
Okay, thank you. So that's it for my questions. Thank you for spending so much time with me on this. On the CLCPA in particular, I do think that this order is consistent with the CLCPA for all the reasons that you explained, and thank you for doing that. I do think that the CLCPA affected the outcome, but is not a major cost driver in this case. I'm convinced the presentation has been persuasive that what could be, siphoned off the company's initial request has been, and what's left is necessary and required by law. So I'm going to vote yes because I don't see a responsible alternative for doing otherwise. Thank you very much.
Thank you. Commissioner Bryan.
Thank you, Chair. Thank you so much for the presentation. It is very difficult to vote yes on a rate increase, and there are so many factors to consider. So I truly appreciate all of your hard work and all the work that's been done here. As you mentioned, this is the company's first increase in 7 years, but also this settlement includes a number of investments that are not just about increased labor costs, which are of course important, but that I felt like were more directly tied to things that benefit the individual customers that are paying the rates. So I wanted to call out a couple and then maybe have you talk about a few as well. So you did mention that the JP supports the continuation of the free legal assistance program, and that these funds are going to be dedicated to ensuring people receive direct legal representation when facing shutoffs or when in need of other emergency services. And I also wanted to note, and I think you noted as well, that the legal firm that is going to be doing this work is local and specializes in giving legal aid to low-income New Yorkers within the company service territory, which I thought was really important. And I'm hoping you can talk about a couple of the other programs in this JP. The one I just spoke about was a continuation of a program, so I think it was just like maybe $5,000 more for this year than it was $5,000 more than it was in the last rate plan. But the methane detector installation program, and then you mentioned a little bit about the enhanced cold weather protection program. These were expanded programs. They existed already and then were expanded. Could you just talk a little bit about the expansion of these programs?
The residential, the residential methane program, I think, has distributed about 3,000 detectors so far, and it's going to expand to 102,000 by the end of the rate plan. It's targeted to vulnerable constituencies, the elderly, disabled, blind, perhaps people who may have difficulty recognizing that there's a leak or knowing what to do about it. So that's that program.
As far as the cold weather protections, Pulp in its initial testimony had proposed expansion of the company's cold weather protections, and the JP adopted many of those proposals with certain modifications. It basically formalizes what in many instances the company was doing, but it provides formalized protections that the company agrees to do, which includes during the coldest months of the year, November through mid-April, the company would accept all heat payments that for active customers and pledges where those heat pledges covered at least half the amount due, and would enter into deferred payment agreements with residential customers who had received and utilized all of their regular or emergency heat pledges during the current plan year, even if there had been a default previously on that, which is a real protection. It wouldn't schedule residential disconnections on days when the temperature was predicted to fall below freezing temperature or certain winter storm alerts were in effect. And also, disconnections wouldn't occur for certain vulnerable populations.
Thank you for just going over those a little bit more. And I think that especially as we go into winter, very, very important programs to expand. So thanks for talking a little bit more about those. A couple of the other things I wanted to touch on, there were some operational efficiencies and analysis that are wrapped into this JP. So you mentioned sort of the energy affordability program and looking at the different tiers and making sure that people are properly classified so they are getting their benefits. I wanted to also mention that the company is reassessing the base cost of gas charge that is embedded in the delivery rates. But then you touched on a little bit, and just to touch on a little bit more, that there's money dedicated to the way the company is interfacing with their customers. So the call center, the customer service portal, and the reopening of the customer assistance centers. So could you talk a little bit more about how these components might simplify the customer experience, but also go a little bit over the metrics, which you did touch on earlier, that are outlined in this order that help us keep track of if we are actually simplifying the customer experience and improving the company's customer service system.
Well, certainly the reopening of the customer assistance centers is going to provide people with an in-person dialogue. Some low-income customers might not have access to an internet communication. So that will just enhance the customer service provisions for the company. And the customer portal is actually a work in progress. But the goal is to create efficiencies for the company so that the actual customer service representatives can focus on emergencies. And it will also enhance customers' abilities to take care of things by themselves. So it's an efficiency measure as much as a customer service measure.
The customer service performance indicators, that's a big component. There are four metrics: that the PSC customer complaint rate, or call answer rate, residential customer satisfaction survey, and estimated bills. These are four different metrics that will be tracked. And along with those is the re-implementation, I guess we would say, of negative revenue adjustments, which is a substantial change in this JP with respect to those components that will provide benefits to customers. And also, the company is expanding its outreach and education programs. And we touched on that a bit with the language access, but in general, they're working to expand their customer outreach.
Thank you. And I look forward to reading those performance reports. I know that we will be getting those, that we get those regularly every year. So I wanted to call out a couple of CLCPA provisions that I appreciated in this JP. One was the adjusting the economic development programs, as Commissioner Majori also mentioned, to be aligned with the CLCPA goals, ensuring that the economic development programs, which were the area development program and the partnership to revitalize the industrial manufacturing economy program, so the PRIME program, ensuring that these programs are considering the CLCPA and our state's emission reduction goals when projects are proposed, I thought was great. And Judge Kersey, you just touched on the outreach, which in this JP I sort of appreciated that there was a focus on disadvantaged communities. So one of the things about that I remark often about how important the CLCPA is for a ton of different reasons, but one of the reasons that always sort of rises to the top is the emphasis the CLCPA had on doing a thorough assessment of what a disadvantaged community is and where they are located across the state. And then built into the CLCPA are intentional ways of ensuring disadvantaged communities are not only not being disproportionately impacted by our actions, but that they get at least 35% of the benefits of the state's climate actions. So I'd love to just hear a little bit more, because I didn't see, I saw in the JP that they were talking about doing more outreach that's specific for disadvantaged communities, but was a little unclear on what that outreach exactly might be.
I think one of the interesting things in this JP was that the signatory parties acknowledged, thank you, that the company had demonstrated expansion of outreach to disadvantaged communities, and so that they had been being successful in that area. I think what's going on right now, particularly, they're continuing to review their work. They're expanding their language access to make sure that the most critical, and not just examining it, but actually moving forward on their language access to, I believe, the 5 most utilized languages in the area, and providing all of their most critical materials in those languages. And then I believe that there's expansion work in their multimedia campaigns, and just making sure that they're getting all of their most critical documents out to the most necessary populations.
I think many of the things that we've described as customer service provisions are also dedicated to the disadvantaged communities, and the outreach is intended to make these communities aware of the efforts that the company is engaging to provide them with all kinds of services. So it's educational as much as customer service.
So maybe even on efficiency programs,
Yes.
or more
Yes.
efficient, things like that. Okay.
And also just their general outreach as to what's going on, and where one of the big things that they were moving forward was their infrastructure and outreach programs, to make sure that when projects are going on that just might affect different communities, that all of the people in those communities are made aware of what's happening, which
Yeah.
just improves daily life.
Yeah. Well, thank you so much to the team for all your hard work, and that was all of my questions. Thank you. I'll be supporting this item.
Thank you. Thank you. Commissioner Sheehan.
Thank you, Chair. As usual, when you get to me, I've heard a lot of people have wonderful comments and really great questions. So I really support and concur with many of the comments that my fellow commissioners have made. I want to thank Judge Clark and Judge Kersey, staff, and the parties for their work on this case. I, like my fellow commissioners, I do look at the comments from the parties that sign on as well as the ones that don't, and just to see, why a party didn't sign on. So I did pay particular attention to that. But on the whole, I do think that the JP and the order I'm supportive of on the whole. So there are 5 specific reasons why 5 key elements to this order that I think are worth noting, and why, for me, it kind of rose to the top. First is the increased emphasis on the non-pipe alternatives, which is really pretty much a new thing for this company to be really focusing on. That the NPAs are something that they will be needing to consider when they evaluate capital projects, and that's also that it's embedded in the economic development programs. The second is the expanded leak-prone pipe replacement program, which does also have an impact on reducing emissions. So I think that's really notable when you look at this in the whole, especially in relation to the CLCPA. The third is the CLCPA programs that are specifically included in the JP, demand response, pilot program, the hydrogen demo project, the hybrid heating demo projects. Fourth is the customer service enhancements, especially the energy affordability program and the cold weather protections program. And then fifth is the additional protection, ensuring that ratepayer funds aren't going to be used for advocacy related work, which frankly I don't think we should ever have to say. It should just be, but obviously it was raised by an important point raised by a party, and I'm happy to see that we're including that in the order. the one thing that I am just curious about, because there are so many new things in this, and I think this might be a Jeff Hogan question, is in relation to, because a lot of this is new and there's new criteria and or expanded programs, is for me it's the implementation, right? So now the part will be these programs being implemented, these key provisions, and how we monitor that they're actually complying with these new provisions and ensuring the oversight that they're being implemented properly.
Sure. I think the primary way we do that is we have so many different divisions here that have specialties. So our customer service staff will be overseeing specific areas that impact customers, right? Obviously, if there's other changes that are going on, we have other. If it's construction related, our engineers will be closely looking at it. But we also have our management audit process, and so when we've now done, we're completing our third cycle of our major comprehensive management audits of companies, and we've looked at sort of the basics a couple times now. But as we get into the next round of management audits, we can look at. We're looking at things where things have changed, where the company's made an organizational change, there's new programs, and making sure that things are going well. So our management audit process will also be providing that oversight. It's not what I would call timely because it's every few years, but that's sort of a backup to our bread and butter daily oversight.
Okay. So just in general, to wrap up, I do think on the whole, the JP ensures safe, adequate, reliable service at just and reasonable rates, and I'll be supporting it.
Thank you. Commissioner Valola.
Yes, thank you so much. And I echo Commissioner Sheehan's sentiments that at the end of the line, I have a lot to agree with and concur and appreciate my colleagues' questions and comments. I, too, feel that under the governing standard of review as a whole, the JP produces a result that is in the public interest and within the likely outcomes of a litigated proceeding. I do have one area that in the future I think I would like to see handled differently. The joint proposal includes what I think are good questions that would be provided in a survey to contractors who supply responsibly sourced gas. And Judge Clark, you had mentioned that these questions or the responses to these questions will provide the Commission and other stakeholders with helpful information to allow us to evaluate whether procuring responsibly sourced gas is aligned with the CLCPA. To my knowledge, as far as I'm aware, the Commission hasn't gathered this kind of data on responsibly sourced gas before. I don't know if you know that answer.
That's correct. We have some programs in place right now that are starting to collect that information with other utilities. Keyspan Energy, which was here earlier on a joint proposal earlier this year. But it's still kind of an evolving area. So we are gathering that information now, but the more information we can gather without overburdening any one utility's customer base while we get that information, is beneficial. So.
Yeah, thank you. That's helpful. I think in the future it would be helpful to have this information before we allow any cost recovery for responsibly sourced gas. I think if we want to ensure that this procurement is aligned with the CLCPA, especially if the information would be received in the form of a survey, that information could be, for example, required as part of an RFP solicitation response that would enable the company and the Commission, if our RFP responses are public, which I'm not sure if they would be, to make a determination of alignment with the CLCPA. With that relatively minor wish for how we approach this issue going forward, again, I feel that as a whole the joint proposal is in the public interest, and I appreciate staff's great work on this case and all of the effort that all of the stakeholders and parties put forth. Thank you, and I will be concurring.
Thank you. I'll now do a call for vote. My vote is in favor of the recommendation to approve the joint proposal with minor modifications as discussed. Commissioner Alisi, how do you vote?
I vote yes.
Commissioner Majori,
Yes.
Commissioner Bright,
Yes.
Commissioner Sheehan,
Yes.
Commissioner Villova.
Concur.
Thank you. The item is approved and the recommendations are adopted. Thank you, everyone. We'll now move to our second item for discussion. Item 201, case 21-M-0351, as it relates to a settlement agreement with National Grid. It'll be presented today by John Sipos and Nicholas Forst. John Castano and Jeff Hogan are also available for questions. John, please begin.
Good morning, Chair Christian. Good morning, Commissioners. I'd like to provide some brief context before we turn to the details of this matter. We're pleased to report that DPS staff and National Grid have reached an agreement here. And the settlement agreement before the Commission today has three main components. First, a condition providing a credit of $20 million for ratepayers. Second, a separate condition that the companies will not seek payment from the ratepayers for over $20 million in costs associated with the company's internal investigation here. And third, a condition that the companies will publicly file a supplemental report in which they describe what occurred and their response and remedy efforts to prevent a repetition of the underlying conduct. Staff today respectfully submits that the settlement agreement reflects an appropriate resolution and advances the public interest. It benefits the ratepayers in the National Grid service territories. It serves to deter individuals from contemplating similar action, similar conduct at other regulated entities. And it provides, through the supplemental report, lessons learned that may be useful elsewhere. And it incents National Grid and other utilities to keep a close watch on contracts for services, contracts for components, and to review concerns or complaints that come through those companies' internal processes. Ongoing criminal litigation and sentencing processes and internal corporate investigations and response activities can add complexities to a situation such as this. Here, DPS staff pursued a deliberate, focused, step-by-step approach, and I'd like to acknowledge the hard work of Allison Manns, John Castano, Tim Canty, Jeff Hogan, Brandon Goodrich, Diana Hediotti, Dave Rossi, and of course, Nicholas Forst, who kept this initiative on course. And with those preliminary comments, I'd like to turn it over to Nick to walk through the agreement. Thank you.
Good morning, Chair Christian. Good morning, Commissioners. Item 201, the draft order before you, adopts the terms of a settlement agreement before the Department of Public Service staff and National Grid, and as my esteemed colleague John Sipos stated, consisting of a $20 million credit to National Grid's customers, preclusion of recovery from customers of approximately $22 million in expenses incurred in connection with the company's investigation activities and enhancements to their internal controls, and provides for the submission of a supplemental report by the companies detailing National Grid's investigation and an acknowledgement of the remedial efforts taken by National Grid to resolve matters associated with the criminal conduct of its former employees. By way of background, on June 17, 2021, the U.S. Attorney filed a criminal complaint in the U.S. District Court for the Eastern District of New York against 5 former National Grid employees. The complaint charged these former National Grid employees with violating a federal criminal statute called the Travel Act, which makes it a crime to use any facility of interstate commerce, such as a cell phone or email, with the intent to engage in certain unlawful activities, including commercial bribery. The criminal complaint alleged a procurement kickback scheme in which the defendant employees received bribes, including cash payments, travel expenses, vehicles, college tuition, and home repairs from vendors in exchange for providing those vendors with various benefits, including contracts with the utility companies. These criminal activities occurred over a 7-year period between July 2013 and July 2020. Vendors paid kickbacks to the company employees, 1, to secure work from National Grid, 2, to receive non-public information about competing vendors' bids for work that was competitively sourced, 3, to structure the value of contracts to avoid scrutiny, 4, to avoid favorable performance reviews, or to obtain favorable performance reviews, and 5, to prevent or avoid negative performance reviews. The defendants exchanged numerous text messages and kept electronic records of payments made as part of the scheme. The defendants also sent coded messages indicating payments were at times insufficient and should be larger in the future. The 5 defendants subsequently pled guilty to the charges pursuant to plea agreements and were sentenced by the federal district court to criminal penalties ranging from 2 years of probation to 1 year in prison. The defendants also agreed collectively to forfeit nearly $1 million derived from their criminal conduct. In response to the federal criminal complaint on June 23, 2021, the Commission initiated this proceeding and issued an order commencing proceeding and requiring a report in this case. The June 2021 order directed the companies to file an investigation report detailing various aspects of the company's operations, including but not limited to the company's internal controls, procurement, invoicing, ethics, and investigation practices. Filed in August of 2021, National Grid's initial report identified the status of the company's internal controls processes, procurement processes, and amounts related to contractor and vendor costs, internal audits, and any remediation or reimbursement plans. Further, the initial report outlined the work National Grid would undertake to improve its controls, procedures, personnel monitoring, in addition to hiring outside legal counsel and independent consultants. Concurrently, in cases 19G 0309 et al., the Commission issued its order approving joint proposal as modified and imposing additional requirements setting rates for KEDNY and KEDLI. The 2021 rate order adopted a 3-year rate plan for KEDNY and KEDLI and made certain modifications to KEDNY and KEDLI's rate plan to address the then ongoing concerns regarding the federal criminal complaint and the company's investigation into the alleged criminal conduct. The Commission required that a portion of KEDNY and KEDLI's revenue requirement be collected through an adjustment mechanism. The Commission established that annually a total of $2.5 million of revenues for each KEDNY and KEDLI would be collected through a rate adjustment clause, or RAC. The RAC proactively set aside a portion of KEDNY and KEDLI's revenues for disposition in this proceeding. During KEDNY and KEDLI's rate plan, the term spanning April 1, 2020 to March 31, 2023, a total of $20 million was collected through the RAC for both KEDNY and KEDLI. Using National Grid's initial report in 2021 as a starting point, the Department pursued a robust investigation, which included the proffering and review of numerous interrogatories, reviewing invoices and expenditures for facilities work, such as building maintenance, landscaping, paving, fencing, and snow removal, and conducting numerous extensive interviews with the criminal defendants and National Grid personnel. During its investigation, staff found 2 instances in 2015 and 2017 where National Grid received reports specifically identifying allegations of kickbacks, bribes, and inappropriate selection of vendors by National Grid's facilities management team, i.e. the criminal defendants. The conduct identified in these internal reports was consistent with the conduct identified in the criminal complaint. While these internal complaints were investigated by National Grid's Ethics Office, the allegations were ultimately categorized as unsubstantiated. Simultaneous with the department's investigation, National Grid pursued its own investigation. The focus of National Grid's parallel investigation spanned 4 key areas: data analytics and forensics, procurement process controls, ethics processes, and culture and personnel. National Grid expended significant resources throughout its investigation, spending approximately $22 million on outside counsel and consultants. National Grid brought on additional resources to support its investigation group, its investigation group convened to respond to the situation. National Grid hired PricewaterhouseCoopers, or PwC, to conduct a data-driven analytic forensic examination to investigate how the fraud occurred and to assist with the calculation of any customer impact. National Grid also retained outside legal counsel to conduct an internal investigation and to partner with the forensic accounting experts. National Grid also engaged Korn & Ferry to conduct a 12-week review of the company's ethics and compliance culture. Stemming from staff and National Grid's investigations and as part of its remedial efforts, National Grid implemented new controls in its procurement processes and developed an artificial intelligence tool to detect patterns of behavior that might indicate misuse, abuse, or avoidance of the controls process. National Grid also created a new financial integrity team to help identify how controls can be manipulated or circumvented. The companies also examined their ethics department and retained Jenner & Block and Ernst & Young to assess the company's ethics program, including whistleblowing and investigation processes. Notably, the companies terminated all of the employees' corporate ethics department during the period the fraudulent activity occurred and replaced them with new staff. National Grid also improved the reporting structure of its ethics department. National Grid and its consultants' efforts are further described in its supplemental report filed with the Commission pursuant to the settlement agreement. Ultimately, under the terms of the settlement agreement, National Grid will credit its customers, Kedney and Kedley gas customers, $20 million in a regulatory deferred liability account funded at National Grid shareholder expense. In addition, the companies agree not to seek recovery from ratepayers of the approximately $22 million incurred in connection with the company's investigation activities and enhancement of internal controls. Further, and as discussed before, National Grid agreed to file with the Commission a supplemental public report detailing the events that transpired in connection with the federal criminal investigation, the plea agreements, and convictions of the 5 former employees, and the specific remedial steps and efforts made thereafter by National Grid regarding its procurement and ethics investigation practices. In conclusion, the Department acknowledges National Grid's cooperation through the Department's investigation and its commitment to a series of remedial actions and efforts towards prevention of similar criminal conduct in the future. While National Grid exercised meaningful corporate stewardship in response to the federal criminal complaint, mismanagement while these acts occurred necessitated investigative action by staff, which culminates in the settlement agreement and today's action by the Commission. The agreement provides National Grid's customers a substantial financial benefit and insulates customers from incurring the costs associated with National Grid's investigation and remedial actions. The agreement is in the public interest and, for the reasons discussed, should be adopted. I also want to extend my appreciation to all of the department staff who've expended a considerable effort to investigate and resolve this matter, including those in Counsel's Office, the Office of Investigations and Enforcement, and the Office of Accounting, Audits, and Finance. I appreciate this opportunity to present this item to the Commission along with John Sipos. This concludes our presentation. John Sipos, Jeff Hogan, and John Cassano and I are available to answer any questions you may have. Thank you.
Thank you. It's unfortunate that this situation happened, and even more so that it wasn't caught earlier. But I'm grateful that we were able to identify the issue and address it and come to a remedy and a conclusion that actually benefits ratepayers in the long run. So thank you for your hard work in bringing this about. I have no further questions. Good work on addressing the issue. With that, I go to Commissioner Alisi.
Thank you, Chairman. I believe that this does provide a substantial financial benefit in a very positive way. It addresses the issue of criminal activities of former employees, as well as the acts or omissions of management, and it also provides the environmental, social, and economic policies of the Public Service Commission, and it's most certainly in the public interest, so I will be supporting it.
Thank you. Commissioner Majori.
Thank you. Thank you for the presentation and the work bringing this issue to resolution. I just have one quick question, which I think is directed to John Sipos. Are you satisfied that these corrupt activities are limited to the 5 employees in question, or even just to National Grid, or are you concerned at all that there might be a more systemic issue?
Commissioner, I think we take each case as it comes. We look at the facts as they're presented, as the United States Attorney's Office developed, as we developed, and as was developed by National Grid's internal investigation, which had some substantial additional support from outside resources, nationally known law firms and accounting companies. So, in connection with Grid, in this facilities and services contract arena, I am satisfied that the problems were identified and that there is an appropriate remedial plan in place to preclude this in the future. I believe that National Grid understands the significance of this situation and is approaching it in a sober, deliberate, systemic manner, based on the record here. Your larger question, I guess, goes to it's more of a question of like human philosophy. There are upstanding people and there are folks who will look to take advantage of situations. I think I think all the offices here in the department, including the Office of Investigations and Enforcement, have the capabilities to pursue allegations and concerns such as this. We have a whistleblower hotline that we monitor, and OIE and I believe the entire department stands ready to investigate, pursue, and hold folks accountable in situations like this.
Thank you for the answer, and again, thank you for your good work on this. And I, of course, will be supporting this item.
Thank you. Commissioner Bryant.
Thank you, Chair. I appreciate all the work that has been done on this. Like my colleagues have said, to do a deep dive into the root causes and the solutions that can avoid this type of thing in the future and deter bad actors and bad behavior. So great work, everybody.
Thank you. Commissioner Sheehan.
Just want to thank you, John, Nick, John, Jeff, your respective teams, everybody involved in this. It was really shocking to read. I'm sure a lot of people had the same reaction. My question is sort of similar to Commissioner Majori's, but maybe on a larger scale. So, is there an opportunity here for lessons learned from this case to maybe be applied to other utilities?
So, the short answer is yes. Absolutely, there is an opportunity for lessons learned here. And in addition to the financial aspects of the settlement that Nick has walked us through, another aspect of the settlement was the publicly filed supplemental report. The how, what, where, when is discussed, and I believe the commission has access to that. But also, how is it addressed going forward? Right. And it is important. I think staff thought it was important for that report to come in, not only for Grid in this situation to put that in the record here, but for other utilities to read this report. Mm-hmm. It is a lessons learned or opportunity, identification of opportunity for other utilities to see as well. And it is, I think, staff's hope that other utilities will review that report, will see what occurred, will see how these individuals were able to exploit the prior contract control process, the prior internal ethics process within the company, and we'll take lessons from those and we'll work hard to improve that, because after all, contracts for services, contracts for components, contracts that utilities let to facilitate their provision of utility service to ratepayers, those contracts are oftentimes paid for by ratepayers. So they have an obligation to ensure that those contracts are fair and appropriate, and there is not extra money being added in, there's extra padding that is running to the benefit of individual employees. So I really, really appreciate your question, and it's something that staff really believed was important here, was to get this out in the open.
Yeah, agree. Thank you all very much for your hard work on this.
Thank you. And Commissioner Vlova.
Thank you. I echo my colleagues' sentiments and really appreciate staff's work on this matter. I think this issue goes to the heart of what it means to regulate in the public service and ensuring that utilities are operating in the public service and public interest. And I look forward to seeing how the continued efforts to identify ways to improve and the lessons learned as they come out. Thank you. And I will be supporting this item.
Thank you. I'll now do the call for vote. My vote is in favor of the recommendation to adopt the terms of the settlement agreement as discussed. Commissioner Alisi, how do you vote?
I vote yes.
Thank you. Commissioner Vajori?
Yes.
Commissioner Bright?
Yes.
Commissioner Sheehan?
Yes.
Commissioner Vlova?
Yes.
Thank you. The item is approved and the recommendations are adopted. And with that, I'm going to recommend we take a 5-minute break. By my clock, it is now 11:54 p.m. Why don't we return at noon? Thank you. Good afternoon, everyone. I now reconvene the session. We are now going to move to item 301, case 22-E-0222, as it relates to electric utilities climate change resilience plans. It'll be presented by Emmanuel Alexis and Richard Schuller. Aphrodita Barty, Paul Dartmenko, Steve Kramer, and Michaela Loeb are available for questions. Emmanuel, please.
Presentation.
We have lost the presentation. All right, one moment while we figure that out. All right.
Good morning, Chair Christian and Commissioners. My name is Emmanuel Alexis, and I'm a Utility Engineering Specialist 3 in the Office of Resilience and Emergency Preparedness. The draft order before you today, if adopted, will approve with modifications the climate change resilience plans filed by Central Hudson, Con Edison, National Grid, and Orange and Rockland, and direct NYSEG and RG&E to file revised plans. Today, we will give you a high-level summary of item 301, and the relevant details are in the draft order. Next slide. In recent years, severe storm events have adversely impacted New York State. To make the electric system more resilient to such storm events, Governor Hochul signed into law an act that added a new subdivision 29 to Public Service Law 66 on February 24, 2022. This new legislation requires New York State electric utilities to file climate change vulnerability studies and resilience plans with the Public Service Commission. On June 16, 2022, the Commission issued an order to initiate this proceeding. On November 21, 2023, the utilities submitted climate change resilience plans to address findings of climate change studies filed on September 22 and 25, 2023. Throughout the study and plan development process, the utilities engage with staff and many stakeholders. Next slide. Each utility study evaluated the infrastructure, design specifications, and procedures to better understand the electric system's vulnerability to climate-driven risk. In these studies, the utilities assessed their transmission, substation, and distribution systems to determine the climate hazards that they are most vulnerable to. For example, substation assets are most vulnerable to flooding and high temperature. As a result of the studies, the utilities updated some of their design standards or guidelines. For example, Con Edison updated substation design flood elevation from FEMA plus 3 feet to FEMA plus 5 feet. National Grid increased temperature design specifications from 32 to 35 degrees Celsius for substation transformers. Next slide. Each plan proposes storm hardening and resilience measures based on strategies or objectives. Con Edison and ONR's plans are based on strategies that will prevent, mitigate, and respond to future events. Whereas Central Hudson, National Grid, NYSEG, and RG&E's plans are based on objectives that will withstand, absorb, recover, and adapt to future events. These objectives and strategies appropriately address the impacts of climate change and consider infrastructure reliability. Next slide. The utilities propose several programs and projects to address the potential climate change vulnerabilities vulnerabilities in the next 10 and 20-year periods. For example, to mitigate against flooding, utilities plan to install flood walls and raise equipment at substations that are in flood zones. To address wind impact, the utilities are proposing selective or strategic undergrounding programs. While a few of the proposed projects are new, the utilities have long considered the resilience of their electric systems as part of the rate case process. In Con Edison's 2013 electric, gas, and steam rate plan, the Commission established a process to address the impact of Superstorm Sandy and to ensure the appropriate climate science was used to address current and future needs for resiliency through a collaborative process with stakeholders. As part of this process, the Commission approved approximately $1 billion in capital spending to fund storm hardening projects. Similarly, the Commission has authorized resiliency-related investments in recent rate plans for all the utilities. Next slide. To comply with Public Service Law 66, each utility established a climate resilience working group to advise and make recommendations regarding the development and implementation of the utilities plan. Additionally, stakeholder comments were received in this proceeding via notice of proposed rulemaking and at in-person public statement hearings held between July and August 2024. The draft order considered comments filed in response to the plans and identified shortcomings that need to be addressed in the current plans and the next iterations of the plans. Next slide. Overall, the utilities plans propose storm hardening resiliency measures that will generally improve the resilience of their systems. However, the plans submitted by NYSEG and RG&E are not adequate because they omit certain information required by Public Service Law 66, Section 29. Specifically, NYSEG and RG&E's plans lack forward-looking projections and cost implementation timelines for resiliency measures that could be implemented in the next 10 and 20-year periods. Additionally, NYSEG and RG&E's plans do not provide the first 5 years of rate impacts associated with the implementations of their plans. Regarding Con Edison, ONR, and National Grid, these companies inappropriately classify some projects as resiliency investment in their plans. These projects do not address a specific change to the company's design standards or operating processes to mitigate identified climate hazards. Regarding adaptations to climate change into internal processes, the utilities and resilience plans lack defined and explicit details with respect to climate change projections. None of the utilities plans address coordination opportunities with telecommunication service providers. And these service providers were not included in the climate change resilience working groups. Currently, there is no industry standard to measure resiliency. And the development of resiliency metrics is an active area of research. The utilities propose to use varying methods to assess and address each program's effectiveness. Some of the methods track the implementation of projects, but they are not capable of gauging the effectiveness of storm hardening and resiliency efforts. For example, tracking the number of devices upgraded or replaced on a circuit will provide information on project completion, but will not give any indication of circuit improvement. Now I will turn it over to Rick Schuler, who will address our assessment of the plan's costs and benefits. Rick?
Thank you, Emmanuel.
Next slide.
So Section 6629 of the Public Service Law requires the utilities have an estimate of the costs and the benefits associated with their plans, especially regarding the undergrounding of electric transmission and distribution lines. Although the utilities provided detailed cost estimates for their plans, due to the complexity and lack of information on benefits, none of the utilities could provide a quantitative comparison of the net present value of the proposed plan cost to the net present value of the associated societal benefits. The utilities instead provided a more qualitative analysis of the benefits of their proposed measures. These more qualitative methods were used as a means to compare the potential benefits between various resilience measures. Utilities should monitor ongoing research related to valuing the societal benefits, such as benefits related to avoiding service outages. We expect that the utilities will address this issue with more specificity in their next iterations of their plans.
Thank you, Rick. Next slide. The draft order determines that the plans of Central Hudson, Con Edison, ONR, and National Grid satisfy the requirements of the legislation. However, the order directs certain modifications to the plans of Con Edison, ONR, and National Grid, and directs they file amended plans in this proceeding within 60 days. These modifications are related to the inappropriate classification of some projects, as I previously discussed. The draft order also directs NYSEG and RG&E to file revised plans within 90 days to address the omission of information in NYSEG and RG&E's plans required by Public Service Law 66, Section 29. The cost and timing of some of the utilities' forecasted climate resilience projects are being assessed as part of ongoing rate case proceedings. This should continue, and future resilience investment should be assessed in upcoming rate case proceedings. No specific resilience surcharge is necessary at this time. Efforts to harden New York State electric system will require many years to accomplish. Because climate science is continually evolving, and as such, the need to mitigate utility vulnerabilities will change over time. As this is an iterative process, the utilities' action to improve their plans' adaptation to climate change projections, performance benchmarks, and resilience metrics should be discussed in ongoing engagement with stakeholders and incorporated in future iteration of the plans. Finally, after the second full year of plan implementation, and every 2 years thereafter, Public Service Law 66, Section 29, require each utility to file a report with the Commission detailing its activities to comply with its plan, and to file an updated plan for Commission consideration at least every 5 years. This concludes staff's presentation. We are now available for questions. Thank you.
Thank you, Meng. Appreciate the work in putting this together. Today's action is a result of a process. This is almost every commission action. And this is a process initiated with the intent of first understanding the vulnerabilities of the electric system and how they'll be experienced due to the evolving climate change risks. And today, this order directs the utilities to take actions in support of addressing the vulnerabilities identified earlier in this effort. Now, resiliency is an essential part of everything that we do. It's essential to ensuring that ratepayers have access to safe, secure, and reliable services at just and reasonable rates. And the Commission, New York State Utilities, we all have a long history of considering resilience in planning. And what makes this order unique and separates it from the past is that we're effectively blazing a new trail. The industry does not have standards and practices that have evolved to the point where our utilities have a standard roadmap to follow. And so we are effectively blazing a new trail in this manner to help identify a path forward using lessons learned from past experiences. And we recognize that this will be an iterative process, and that over time, as our understanding and the understanding of best practices evolve, so too will the process, as well as the resulting recommendations. And I think about the guidance that you've highlighted, where we need to improve and the things that we've directed utilities to do. And I think I could best describe them as the need for greater transparency and specificity in both the data used, the methodology behind the analysis, and how various considerations are weighed. And I'm looking forward to seeing those in subsequent plans and reviews as we go forward. So again, thank you for putting this together. Thank you for the review, and I support this item. With that, Commissioner Alisi.
Thank you, Chair, and thank you to all of the people that worked hard to put this together. It's important that we keep abreast of not only what has happened, what is happening, and where we're going down the road. So I appreciate what you've done here, and we'll stay alert to the next issue.
Thank you. Commissioner Majori.
Thank you. I don't have any questions. I'll just comment that, 6629 is a new law, and a new law is passed to modify behavior. So the utilities are being asked to do something that they wouldn't necessarily do on their own anyway. But it's not like utilities didn't plan to improve resilience as part of the normal, the rate case process, as was mentioned in the presentation. So I appreciate the work that you guys have done, and I also appreciate that we're just not rubber stamping the utilities' plans. As the chair said, we're blazing a new trail here, and we're at the very beginning stage of a process to try to enhance our resilience in the face of ever increasingly severe weather as a result of climate change. So I thank you for the presentation, and thank you for the work, and look forward to what comes next. So I'll be voting yes. Thank you.
Thank you. Commissioner Bryant.
Thank you, staff, for the presentations. I have no questions. I think it's important that we're assessing and fortifying our systems, and particularly in the face of climate change and the ever intensifying impacts it has on our systems and our communities. I appreciate that we are also recognizing that we don't have all the answers yet, and are making sure that this is an iterative process, so we can address the shortcomings and add more detail in future plans as the utilities continue to evaluate their vulnerabilities and their needs. So great presentation, and thank you. I'll be supporting this item. Thanks so much.
Thank you. Commissioner Sheehan.
Thank you, Chair. Thank you, Emmanuel. I appreciate your presentation, and Richard. I really do appreciate the work in this area by yourselves, as well as the utilities and the stakeholders, given that this is, a new area and everyone is learning, including us. One thing that I don't think we covered in the presentation, but I think is important for an understanding of what's in the order and what's not, is that the specific projects in the plans are still subject to individual rate cases. I just want to make sure that that's communicated.
Yes, that's correct.
So the plan being approved, even with modifications, doesn't mean that the project's going to happen tomorrow. It's still going to be considered in the context of individual rate cases.
Yes, Commissioner.
Okay. So now, how will your team intersect with rate cases then in bringing forward these projects?
So resilience staff is assigned to every single electric rate case. And as the order states, that during rate cases, the staff team will take a holistic approach to utilities, electric capital programs, and O&M programs, and evaluate shortcomings there, and then prioritize the funding within the rate proceedings.
Okay. Thank you. I thought that was worth highlighting. So thank you all for your work on this. I'll be supporting.
Thank you. Commissioner Vlhova.
Thank you. Yeah, thank you for the presentation. I will also be supporting this item. And I found the list of major storms at the beginning of the order really sobering. Just the reminder of the storms that New York has been hit with. And I think it's also a really sobering reminder that there is a human cost to these storms. You know, we're not just talking about the electric grid, we're talking about the impacts that people, businesses, and individuals and communities suffer as a result of these storms. So I view the public service law that enables us to do this work and the process of developing and implementing the plans as a no regrets approach to safeguard New Yorkers from as much as possible future harm. And I also want to say I really appreciate the data-driven approach in this process. As you've noted, we don't have all the data yet on all the inputs that go into these plans. Like, we don't have, nationally recognized, standardized resilience metrics. There was interesting discussion about what data to use to determine the accuracy of future sea level rise. So we don't necessarily have to know everything, but the fact that we're coming together to have these conversations, and that we have the benefit also of stakeholders with analytical expertise from academic institutions and other sources to help buttress our own understanding is incredibly helpful. So thank you again to staff and to the utilities for developing their plans, and for all the stakeholders who provided data and input here. And thank you to staff for the very careful review of the plans and identifying the areas of improvement and those that are deficient, so that we can make sure that this work has its intended impact. Thank you.
Thank you. I'll now do call for a vote. My vote is in favor of the recommendation to direct revisions of the climate change resiliency plans submitted by NYSEG and RNGE, and to approve the remaining plans with the modifications as discussed. Commissioner Alisi, how do you vote?
Yes.
Thank you. Commissioner Majori.
Yes.
Commissioner Bright.
I vote yes.
Commissioner Sheehan.
Yes.
Commissioner Vlhova.
Yes.
The item is approved and the recommendations are adopted. Thank you all. Great work. And now we will move to the consent agenda. Do any commissioners wish to comment on or recuse from voting on any items on the consent agenda? I'll begin with Commissioner Alisi.
No comments or questions, thank you.
Thank you. Commissioner Majori.
Yes, I'm going to comment on one item, which is 269, 24M0327. I'm going to concur on this item. This order would authorize Iberdrola to reacquire the remaining approximately 18.4% of the stock of Avangrid, subject to conditions imposed by the order to minimize risk to ratepayers. According to staff analysis, the stated benefits of the initiative, lower financial market compliant costs and improved access to capital, are immaterial. And contrary to Iberdrola's assertions, the transaction does have costs and could pose certain risks, which is why we mitigate those risks through the conditions of this order, specifically requiring financial transparency and assurance that NYSEG and RG&E will not recover the transaction costs from ratepayers. So I support all that. The reason I'm concurring rather than simply voting yes is that given that Iberdrola will pay a total of $2.5 billion to acquire the outstanding shares of Avangrid, and that the stated reasons for doing so are enhanced access to credit markets and investment and operating capital, which we dispute, as well as, quote, intangible benefits, and given that our conditions ensure that the company will not benefit at the expense of ratepayers, which I'm not saying was their motivation, I just don't see why we're doing this. That said, there's nothing in the record giving me a reason to vote no, so simply by virtue of that fact, I'm going to concur rather than vote yes. And I'm going to vote yes on all other items. Thank you very much.
Thank you. Commissioner Bright?
Thank you, Chair. I will be voting for all items. I did want to comment on item 387, implementing large-scale renewable programs in the Clean Energy Standard, the NYSERDA 2025 Clean Energy Standard administrative budget. So my comment is really just that NYSERDA's administration of these crucial programs, crucial and important programs, is being funded by surplus funds and not ratepayer dollars. So these programs instead are being funded by revenues NYSERDA has received in previous years from alternative and voluntary compliance payments, bid fees, investment income, contract security forfeitures. So when contracts cancel, they pay a penalty. So I notably found that the proposal for using these funds was to be really smart and taking some people who are currently contractors and converting them to full-time employees, and in places where we know we will need the people power, so Tier 1 and Tier 4 work. I appreciate the report and the plan, and also want to acknowledge that some of the commenters had other ideas for how to use the funds, but respect staff's assertion that these funds should be used to offset these specific costs. But also that we have additional programs like the statewide Solar for All and NYPA's REACH program that the Commission recently approved, and will continue to have programs like this that are aimed at getting bill credits to energy affordability program customers, particularly in areas that have been designated by the CLCPA to be disadvantaged communities. So I will be supporting all items, but wanted to comment there. Thank you, Chair.
Thank you. Commissioner Sheehan?
Thank you, Chair. I will be recusing from items 373 and 375. And I do just want to acknowledge the hard work by all the staff on these consent items. I know, there's a lot here. So I know this work doesn't happen without your hard work. And as we come to the close of the calendar year, I just want to acknowledge all of the hard work that brought these orders before us today. So thank you.
Thank you. And Commissioner Villova?
No recusals, no comments.
Thank you all. I'll now do the call for a vote. My vote is in favor of the recommendations on the consent agenda. Commissioner Alisi, how do you vote?
Yes on all items.
Thank you. Commissioner Majori?
Yes on all items except for 269, which I'm concurring on. Yes on everything else.
Thank you. Commissioner Bright?
Yes on all items. Thank you.
Thank you. Commissioner Sheehan?
Yes on all items, with the exception of 373 and 375, from which I am recused. Thank you.
Thank you. And Commissioner Villova?
Yes on all items.
Thank you. The items are approved and the recommendations are adopted. Madam Secretary, is there anything further to come before us today?
There is nothing further for today.
Thank you. And with that, I want to wish everyone a happy holidays and a happy new year and adjourn our final meeting of the year. Thank you all.